Hello everyone, hope all of you are safe and healthy. Welcome to IASbaba's Rapid Revision Series for Prelims 2021. This is session 71 and day 99, and the topic we have is Indian polity and other current affairs events. So these are the hot topics we are going to discuss. The first two topics, they go with the guessworks as usual, and then the third one, the 127th Constitutional Amendment Bill, and then preventive detention, and then Article 371. Friends, here we discuss all the special provisions for the states starting from 371 to 371J. Then the National Commission for Women, and then Ujjwala 2.0, then Garib Kalyan Rozgar Abhiyan, then TAPAS Initiative. Now, coming to the first one, the MCQ. With reference to the book Desher Katha, written by Sakaram Ganesh Dioskar during the freedom struggle, consider the following statements. It warned against the colonial state's hypnotic conquest of the mind. Then it inspired the performance of Swadeshi street plays and folk songs. Then the use of Desh by Dioskar was in the specific context of region of Bengal. Now look to the extreme statements. Friends, it warned. So warning is a moderate word, and we cannot say that it didn't warn anything. And then inspired, we cannot even say that it didn't inspire anything. But however, with specific context of region of Bengal sounds extreme. And instead of specific, if there was a word like largely in the context of the region of Bengal, then 3 would also have been correct. But however, now we can eliminate 3 and 1 and 2 stands to be correct. So option A will be the answer for this. Then come to next one. The Gandhi-Irwin Pact included which of the following? First one, the invitation to Congress to participate in the Roundtable Conference. Then withdrawal of ordinance promulgated in connection with the civil disobedience movement. And then acceptance of Gandhiji's suggestion for inquiry into police excesses. Then release of only those prisoners who were not charged with violence. Friends, here no clues are given, but however fourth one provides an extreme word, that is only. But this is also a trap question. If you mark this, we will go wrong. But again, mind you friends, UPSC is never a by heart exam. It is an observational exam, and I bet my life for that. For example, take the Spectrum book, and here come to these 2 points. That is, the Viceroy, however, turned down 2 of Gandhi's demands. So what were those? Public inquiry into police excesses, and then commutation of Bhagat Singh and his comrades. So here public inquiry into police excesses was turned down, and only 2 were turned down. And here we have police excesses as one of the options, and we straight away mark 3 as the wrong one. And here we have 1, 2 and 4, that is B as the option, and we straight away tick 1, 2 and 4 because C and D they contain 3 and A contains 1 only. But however, going through the fourth statement, we get to know that this is somewhat correct because all the political prisoners who were not indulged in violence, it is justified to release them. And even the very first statement of the Spectrum book, it provides the same. So if you observe properly and if you give only 2 reads of this content, then you can easily answer this question. So it is all about your mindset and interest to read those facts and just try to memorize them, not fully memorize. So do it. Now come to next one. The Vital Vidwansak, the first monthly journal to have untouchable people as its target audience, was published by Gopal Baba Valankar, then Jyotiba Phule, then Mohandas Karamchand Gandhi, then Bhimrao Ramji Ambedkar. Friends, Jyotiba Phule, Mohandas Karamchand Gandhi, then Bhimrao Ramji Ambedkar. We know what books they have written, and Vital Vidwansak we didn't study at all. So you can cash on your ignorance and you can hit A as the option. And moreover friends, Vital is something like Kandoba or Purandar Vital, which is a Marathi word. And friends, this Gopal Baba Valankar, this Mumbaikar Valankars, they are from Maharashtra. So even this will match, and you can justify your guess with this match. And straight away go and hit it, and even if you go wrong, there is no remorse because you have tried this. Then come to next one. With reference to history of India, the term Kulyavappa and Dronavappa denote the measure of land, then coins of different monetary value, then classification of urban land, and then religious rituals. Friends, once again, no clues are given, but if you are good at Hindi or Sanskrit, then you can answer this question. Friends, Vapa means Vyapa. So Vyapit hua hai. The Hindi word Vyapit means it is spread. So Delhi Yamuna Nadi ke tir par Vyapit hai. Friends, Delhi is spread over the banks of Yamuna. So this Vyap is something related to land, that is measurement of land. So if you are good at Sanskrit, you can take a hit over. So that is why friends, be Indians, learn as many languages as possible, and it will be helpful for you not only in the prelims, but once you become IAS, if you know 2 to 3 languages, then you can handle the crowd properly. So do it. Then come to next one. With reference to India's Desert National Park, which of the following statements are correct? That is, it is spread over 2 districts. Then there is no human habitation inside the park. Then It is one of the natural habitats of Great Indian Bustard. Friends, here the statement 2, that is, there is no human habitation at all. It is too extreme and we will strike it down. Friends, we know that in the national parks, the human entry is not allowed. But however, we cannot evacuate the tribal people who are living there from last 2 to 3 centuries together. So, though it is a national park, but still the tribal people, they can reside there. So, we take out 2 and 1 and 3 will be the answer. So, here if we take out 2, only C will be remaining, that is 1 and 3. Once again an easy question. So, this is all about today's guessworks. Then come to next one, the 127th Amendment Bill. Friends, why was it in news? Because recently the Constitution 127th Amendment Bill 2021 was passed in both the houses of the Parliament. Yes friends, in that context it becomes important. So, we will look into a brief history of that. Friends, the government of Maharashtra, it came up with 13% reservation for Maratha people in the state employment. And this was challenged in the Bombay High Court, and the Bombay High Court, it upheld the reservation but reduced this percentage to 12%, and this was further appealed in the Supreme Court, and the Supreme Court, it straightaway struck down such reservation because it crossed the 50% limit of the Indira Sahani case judgment. So, that is why it said that no, such a reservation are void against the Constitution. So, to counter this, the government of India, it came up with the Constitutional Amendment Bill. And Supreme Court not only said that this reservation is crossing the Indira Sahani case, but it also said that as per the 102 Constitution Amendment Act, only the President with the recommendation of National Commission for Backward Classes, only he has the power to recommend a particular group as the backward class, and no other state governments, they have the power to list a caste under the backward class list. And now this 102 Amendment Bill, it counters them. So, now we will look into some of the facts. First one, it seeks to clarify some provisions of the 102nd Constitutional Amendment Bill. Yes, it does. We discussed right now. Then, the amendment was necessitated after Supreme Court in its Maratha reservation ruling in May upheld the 102nd Constitutional Amendment Act, and it had said that President, based on the recommendations of the National Commission for Backward Classes, would determine which communities would be included on the state OBC list. So, only President on the recommendation of NCBC has the power to list a caste under the OBC list. No other state governments, they have it. So, this was present in 102nd Constitution Amendment Act and Supreme Court upheld it. But however, Supreme Court turned down the Maratha reservation. Now, the provisions of the bill, the 127th Constitutional Amendment Bill, it amends clauses 1 and 2 of Article 342A and also introduces a new clause, that is the Article 342A clause 3. Then, the clause 3 of Article 342A clarifies that states and union territories will have the power to identify and specify the socially and economically backward classes for their own purposes, and that such a list may differ from the central list. So, this clause 3 of Article 342A, it gives the power for the state governments to have its own list of the backward classes. So, this is the first amendment. Then, come to more amendments. The bill also amends Article 366 clause 26C and then Article 338B clause 9. So, what all this? That is, it is designed to clarify that the states can maintain the state list of OBCs as was the system before the Supreme Court judgment. Yeah, friends, even before the Supreme Court judgment, there was some autonomy given for the states to maintain their own OBC list. But however, the Supreme Court judgment had repudiated it, and now the bill is setting the things to the normalcy. Then, Article 366 clause 26C defines socially and educationally backward classes. So, this clause is amended for this one. Then, the state list will be completely taken out of the ambit of President and will be notified by the state assembly. So, there is no hand of the President in it, only the state assembly can prepare a separate list. Then, the states will thus be able to directly notify the socially and educationally backward classes without having to refer to the National Commission for Backward Classes. So, now the current status is that states have the power to have their own OBC list, and that too recommended by the assembly, not by the NCBCs. But however, they don't have the power to exceed the 50% reservation limit as specified in the Indira Sahani judgment. And many parliamentarians, they urged the parliament to amend and remove the Indira Sahani judgment also, but that didn't happen. So, this 50% limit, it stays even today. So, this is all about the 127th Constitutional Amendment Bill. Then come to next one, the preventive detention. Friends, why was it in news? Because recently the Supreme Court of India ruled that preventive detention could be used only to prevent public disorder. So, in no other reasons, preventive detention can be imposed. Then, the rulings and directions of the Supreme Court's judgment, the court must ensure that the facts brought before it directly or inevitably lead to a harm, a danger or alarm or feeling of insecurity among the general public. So if these criteria are fulfilled, then the courts can go ahead with the preventive detention, else they cannot. Then, while deciding preventive detention, the court must ask whether the ordinary law of the land was sufficient to deal with the situation. If the answer is in affirmative, that is, if the answer is yes, then the detention order will be illegal. So, if the ordinary law would suffice in dealing with the case, then you cannot impose preventive detention. Then, to invoke the public detention law against someone, it is not enough that his or her actions pose a threat to law and order, but must affect the public order. So friends, the judgment, it clearly differentiates the law and order and public order. Friends, violation of law and order means violation of any single law, but harming the public order means creating chaos in the public. So if there is a harm to the public order, only then the preventive detention can be made, and it cannot be made for violation of any single law or any violation of the law and order which is normally in place. Then preventive detention must fall within the framework of Article 21, that is the due process of law, then read with Article 22, that is safeguards against arbitrary arrest and detention, and the statute in the question. So on the statute on the basis of which the case is being dealt, that is the one framework, then the other boundaries are the due process of the law and safeguards provided in the Constitution against arbitrary arrest and detentions. So within these boundaries, the preventive detention has to take place. Now come to more facts regarding the preventive detention. Article 22, it provides for protection against arrest and detention in certain cases, and within the same article the preventive detention also comes in. Now coming to the facts, no law providing for preventive detention shall authorize the detention of a person for a longer period than 3 months. So these 3 months should be the limit within which the preventive detainee has to be released, and unless an advisory board has reported that there is, in its opinion, sufficient cause for such detention. So if the advisory board, which is consisting of those people who can probably become a high court judge, if they provide in report that yes, there is a need to extend the detention, only then the preventive detention can be extended beyond 3 months. Else, every detainee has to be released within 3 months. Then, when a person is detained in pursuance of an order, then the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made, and shall afford him earliest opportunity to make a representation against the order. So the order making authority, he has to communicate the charges to the kith and kin of the detainee, and he should also provide opportunity to the legal representation, that is to bring a lawyer to the court of law and plead the case. So these are few clauses provided in the Constitution regarding the preventive detention. Then come to the next one, Article 371. First one, Article 371 itself, and that deals with Maharashtra and Gujarat. Friends, this article provides a special case for establishment of a separate developmental boards for Vidarbha, Marathwada and the rest of Maharashtra and Kutch and rest of Gujarat. So in regions of Kutch, Vidarbha, Marathwada, etc., these are basically the drought-ridden areas, and separate development boards, they go a long way in bringing equitable development in the state. So that is why the provision is given. Then equitable arrangements providing adequate facilities for technical education, vocational training and adequate opportunities for employment in the state services. So for all native Maharashtra and Gujarat people, the technical education and vocational training should be encouraged. So this is also a provision. Then come to next one, Article 371A. This is concerned with the Nagaland, and it states that no act of parliament shall apply to the state of Nagaland in respect of the religious or social practices of Nagas and even the Naga customary laws. Then it shall apply to Nagaland only after the state assembly passes a resolution to do so. So if any law that affects the customary laws and traditions of Nagaland shall be applicable only after the resolution in favor of applicability is passed in the Naga state assembly. Then the land and its resources in that state belong to the people and not to the government. So the transfer of land properties is based on the people's customary law and not on the basis of the rule of law. So these are the special provisions. Then come to next one, Article 371B. It relates to Assam, and it is to give autonomy and voice to the tribes. So more autonomy and voice to the tribal people of Assam is the special provision. Then President to constitute tribal welfare committees, and the members of these tribal welfare committees should be the MLAs from the tribal areas only. So these are the provisions for Assam. Then come to next, Manipur. President to constitute tribal welfare committees. Again similar to Assam. Then the governor must submit an annual report regarding the administration of the hill areas. So here the governor's report is special one. So friends, Assam and Manipur, they have similar clauses. Then Article 371D and E of Andhra Pradesh. Friends, here the equitable opportunity and facility for the people of the state in health and education and other developments. Then safeguarding their rights in matters of employment and education. And then Parliament may by law provide for establishment of university in Andhra Pradesh. Friends, this is basically related to bifurcation of Andhra Pradesh from Tamil Nadu. So for this, the health and education equitability is being preferred, and also the Andhra University is also recommended. So this is all about the Andhra Pradesh special provisions. Then come to next one, Article 371F. Friends, this refers to Sikkim, and here the Legislative Assembly shall consist of not less than 30 members. So this 30 members limit, it is provided in the constitution itself for the Sikkim state. Then seats in the assembly are provided to people of these different sections. So friends, we know that in Sikkim there are diverse tribes living, and for all the tribes equal representation should be given via proportional representation in the assemblies. Then Article 371G, that is specific to Mizoram. Here an act of parliament would not only apply to Mizoram in matters relating to religious or social practices of Mizo and Mizo customary laws, and it also applies for the ownership and transfer of the land and its resources. So friends, just like Nagaland, it protects its customs and traditions and the customary laws. Then Article 371H, it relates to Arunachal Pradesh. Here the governor has special powers on the state's law and order situation. So for Arunachal Pradesh, this is the law and order which is the special provision. And also the governor can overrule the chief minister's decision on the basis of this provision. So here the governor is given more power over and above the chief ministers regarding the law and order. Then come to next one, the Article 371I of Goa. So here the Legislative Assembly of the state of Goa must consist of not less than 30 members. So this is very similar to the Sikkim. Then Article 371J. Here the Article 371J grants special status to 6 backward districts of Hyderabad Karnataka region. So this is basically fixated to Karnataka. Then a separate development board be established for this region, and it also ensures local reservation in education and government jobs. Friends, these 6 Hyderabad Karnataka region, they are the districts of Karnataka and they border the Andhra Pradesh state, and these are drought-ridden districts and they require special privileges. So that is why it was being brought in. So these are all about special provisions for various states, and friends, these become important in the wake of removal of Article 370, which is also a special provision given to J&K. Then come to next one, the National Commission for Women. Friends, why was it in news? Because Miss Rekha Sharma was being nominated as the chairperson of the National Commission for Women for another term of 3 years by the central government. So an extension has been given for Rekha Sharma. Now more about the NCW. It was set up as a statutory body under the National Commission for Women Act 1990. So it is a statutory body and not a constitutional body. Then the objective of NCW is to represent the rights of women in India and to provide a voice for their issues and concerns. Friends, this is a generalistic objective. There is no need to by heart this. Then composition of NCW. The commission consists of a chairperson, a member secretary and 5 other members. So it consists of 1, 2 and 5. That is totally the 7 members. Then the chairperson of NCW is nominated by the central government. So it is just nomination. There is no appointment. There is neither appointment committee also. Then the central government also nominates the member secretary. So even the second member, that is the member secretary, is also nominated by the government. Then the 5 other members nominated by the central government should have experience in legislation, management, women voluntary organization, economic social development and so on. So experts in the legislation, management and other areas are being nominated. So friends, all the members are being nominated including the chairman and the member secretary. Then come to more facts, the functions of the National Commission for Women. First one, investigation and examination of laws related to women. So all the laws related to women are examined and the amendments are suggested. Then it takes care of complaints and also suo motu matters about the deprivation of rights of women. So if any incident occurs which are derogatory to women, then the NCW can take the suo motu cognizance. Then assessing the development and the progress of the women community. So overall growth and development of women is also a job of NCW. Then inspect the jail and remand home and ensure women's safety. So the women prisons and women remand rooms are being inspected periodically by the NCWO. Then presentation of reports to the central government every year. So regarding all its recommendations and investigations, a report is made and it is submitted to the central government, and it is done every year. Then powers of NCWO: issuing summons for the examination of documents and witnesses, then receiving evidence on affidavits, then discovery and production of documents. So basically it has the power of a civil court. So it is a quasi judicial body, we can say that also, and this is all about the NCWO. Then come to next one, Ujjwala 2.0. Friends, in the union budget for 2021-22, provision for an additional 1 crore LPG connection under the Ujjwala scheme was announced. So friends, additional 1 crore LPG connections is nothing but Ujjwala 2.0, and these aim to provide deposit free LPG connections to those low income families who could not be covered under the earlier phase of this Pradhan Mantri Ujjwala Yojana. So but obvious, this additional 1 crore is provided for those who were missed out in the 1.0. Then Ujjwala 2.0 will also provide first refill and hot plate free of cost to the beneficiary. So the first refill will be free and the hot plate will also be free. Friends, hot plate means a stove like thing which is fixed on the cylinder. Then in Ujjwala 2.0, migrants will not be required to submit ration cards or address proofs. So without ration cards or address proofs of the residents, this Ujjwala 2.0 can be availed. Then a self-declaration for both family declaration and as a proof of address will suffice. So any self-declared document will suffice. There is no need of authenticated documents also. So friends, this is for those who missed in the Ujjwala 1.0, and this provides free first refill and a hot plate, and no ration cards or address proofs are required, and only self-declared documents are sufficient. Then come to more facts. The eligibility criteria to avail the connection under Ujjwala 2.0. First one, applicants, the women only must have attained 18 years of age. So women only can apply, and those above 18 years can apply. Then there should not be any other LPG connection from any oil manufacturing company in the same household. So this woman should be the lone person who is having access to LPG connection in one home. So one house, one connection. Then adult women belonging to any of the following categories, they can avail for Ujjwala 2.0, that is the SC woman, ST woman, and then Pradhan Mantri Awas Yojana beneficiary, and that to the Gramin beneficiary. Then most backward classes people, they can also avail. Then Antyodaya Anna Yojana beneficiaries, so those lower pyramid people, they can also avail this. Then tea and ex-tea garden tribes, and then forest dwellers and people residing in islands and river islands, and then who are enlisted in the socio-economic caste census households, so even they can avail the scheme. And then any poor household as per the 14-point declaration. So this 14-point declaration under Indian Poverty Program, this provides certain criteria. So any persons who are fulfilling such criteria, they can avail Ujjwala 2.0 scheme. So this is all about Ujjwala 2.0. Then come to next, the Garib Kalyan Rozgar Abhiyan. Friends, Government of India had launched the Garib Kalyan Rozgar Abhiyan in 6 states of Bihar, Jharkhand, Madhya Pradesh, Goa, Rajasthan and UP. So here we can remember Bihar, Jharkhand, Madhya Pradesh, Odisha, Rajasthan and Uttar Pradesh as BJMORU or the Bajamoru. So you can remember like this and remember those 6 states. Then to provide gainful employment to migrant laborers who had returned to their native villages due to the outbreak of COVID-19 pandemics. Yes friends, basically for the Bimaru states wherein people out-migrate for the sake of jobs, only for those states the scheme is concentrated. Then Ministry of Panchayat Raj undertook facilitation of 2 activities. So it is basically implemented by Ministry of Panchayat Raj, and then construction of Gramin Panchayat Bhavans and works under Central Finance Commission grants. So these are the works undertaken. So friends, those funds which are being remaining after spending the Finance Commission grants are being utilized for this scheme. Then the panchayats in the 116 Garib Kalyan Rozgar Abhiyan districts were provisions with the funds to the tune of 9,554 crores for undertaking the works under Finance Commission grants in the rural areas. So friends, the huge funds have been lapsed from the funds of the Finance Commission, and all those funds are being utilized for this Garib Kalyan Rozgar Abhiyan. So this is all about the GKRA scheme. Then come to next one, TAPAS Initiative. Friends, why was it in news? Because recently the Union Minister of Social Justice and Empowerment has launched an online portal TAPAS. So friends, this is basically from the Ministry of Social Justice and Empowerment and not from the HRD or the Human Resource Development Department. So friends, that facts you will remember. Then this TAPAS is a portal and the full form is Training for Augmenting Productivity and Services. So this TAPAS portal, it basically trains for augmenting one's productivity and employability. Then about TAPAS initiative, it is initiated by the NIST, that is the Ministry of Social Justice and Empowerment. So friends, we know that the NIST is the National Institute of Social Defense and it is an advisory body to the Ministry of Social Justice and Empowerment. So this NIST we will remember. Then it seeks to provide access to lectures by subject experts and also seeks access to study materials and many more. So lectures and notes are being provided. So this is basically an educative program. Then it can be taken up by anyone who wishes to enhance his or her knowledge. So it is open to all scheme and there are no criteria or eligibilities. Then it is a standard MOOC, that is the massive open online course platform with course material such as film lectures and e-study material. So online classes and notes are being given and it is a part of MOOCs. Friends, we know that MOOCs, Swayam, these are related to the offline and informal classes to educate those people who have dropped out. Then it also includes discussion forums to support and encourage interactions among students and course coordinators. So not only learning via lectures and notes, we can also have discussion with the mentors and coordinators. Then there will be virtual classes also. Yes friends, but obvious, lectures will be included. Then student can assess their understanding of the subject with the help of multiple choice questions. So once the module is over, then students can take up these MCQs and they can assess their knowledge. So this is all about the TAPAS initiative, and here is a brochure regarding the TAPAS initiative that is being put out by the Ministry of Social Justice and Empowerment. Then come to the last part. Friends, going back to the history, friends, Adolf Hitler was about to attack Poland and many of his subordinates asked why the hell he was taking such a drastic decision, and his reply was that he has prepared for the worst and he is hoping for the best. Friends, the same way you have to prepare for the worst possibilities, but you should hope for the best. And also friends, Adolf Hitler famously said that before taking a decision, think 1000 times, and once you take a decision, even if 1000 hurdles come, never turn back, never quit that. So do it with utmost fortitude and perseverance and reach the zenith. All the very best. Good luck friends.